I don't want to call them hypothetical, but they're something that's going to have to be worked towards as he gets himself with his feet underneath of him, transitioning out of an inpatient facility.
All right, Mr. Yeaman, can I have you state your name and date of birth, please, for the record?
Scott Yeaman, January 4th, 1969.
Looks like you are entering 3 pleas to 3 different domestic violence no contact order violations. Is that your understanding today?
Yes.
Have you had plenty of time to talk to Mr. Campbell?
Yes.
Need any additional time?
I do not.
You are 56 years old and you've completed 20 years of education. Is that correct?
Yes.
Are you able to read and understand the English language?
Yes.
Entering pleas today to the 3 domestic violence no contact order violations, you are giving up some important rights that we're going to review on the record. These rights apply to each one of your cases. You have the right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed. You have the right to remain silent before and during trial and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you. You have the right at trial to testify and have witnesses testify for you, and the witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty, and you have the right to appeal a finding of guilt after trial. You understand those rights, Mr. Yeaman?
Yes.
Understand that in pleading guilty today, you're waiving or giving up those rights.
Yes.
Each of the 3 charges are gross misdemeanors. They're each subject to 364 days in jail and a $5,000 fine. There is a pretrial agreement that I'm holding up, sir. Do you understand the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law?
Yes.
Court can place you on probation for 5 years, during which time you pay cost, fees, and assessments as authorized by law. There are some portions of your plea paperwork that have been marked. There's a portion that talks about violating a domestic violence protection order has a mandatory fee of $15. You understand that is not subject to waiver and something the court has to impose.
Yes.
Also, conviction for domestic violence charge prevents your ability to both own and possess firearms, both now and in the future. Again, do you understand that that is a mandatory condition of the court?
Yes.
To the charge of domestic violence no contact order violations, there was 3 total taking place on September 24th, 2024 in the city of Richfield, Washington. How do you plead to those 3 violations?
Guilty.
Has anyone made any threats or promises to you to get you to plead guilty?
No.
Are you entering the pleas freely and voluntarily?
Yes.
Factual basis states as follows. On or about September 24th, 2024 in the city of Richfield, Washington, in 3 separate and distinct acts, I did contact Pilar Yemen, my wife. Can't read your handwriting. Something with text or phone call, directly via text or phone call, in violation of the restraint provisions of a validly served no contact order. Is that correct?
That's correct.
Mr. Yemen, is that a correct factual statement?
Yes.
Accept the pleas. I'll find them knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. Go ahead, Mr. Campbell.
Your Honor, this is a situation where Scott understands he had a potential diminished capacity offense in relation to these charges. He had some charges over in Oregon as well. He's taken responsibility for. He was in a mental health crisis surrounding also some very significant medical events. That doesn't take away from the impact that happened to the victim in this case. I mean, I think it was a substantial event. Pilar, I think he and the victim, his wife, have been navigating a divorce action. I looked in Ogen today. That action is nearly finalized. It looks like there's just a kind of last bit of work that needs to be done to enter the final orders. So I haven't been able to find filed orders signed by the victim that substantiate this, but I'm very confident that what my client tells me is correct. He's been in an inpatient mental health facility for almost a year. He's asking jointly between the proposal from the city and himself for getting 30 days of credit for time served for that time that he's been in treatment. He's continuing to be in treatment. He has not been able to work since he has been in treatment. He is a dentist, but that work nearly killed him, the stress and rigor of it in the context of what is also a very significant mental health episode. So
let me understand. So he's getting credit for jail for the inpatient treatment that he did?
that was the negotiated settlement
Okay.
agreement.
I'm just
between-
trying to make sure I understand.
And yeah, I found that a little bit curious too. I don't know how exactly you want to note it on the judgment and sentence, but what he's getting 30 days of credit against his total sentences in all three cases concurrent for the purposes of the work that he has done on his mental health. I think if he hadn't done that work, there was a ITA holdover in Oregon. His mental acuity was so significantly impacted. He was near death, and he is in a much better place today, but still recovering from what has been a very significant impact to his ability to meaningfully engage in things. I'd ask Your Honor to find him to be indigent just based off of the catastrophic mental and physical episode that he's had. He's still living in Southern Oregon at an inpatient facility, if I'm not mistaken. Are you still down at Grants Pass, Scott?
Yes.
The no contact order, I'll be clear with Your Honor, we haven't been able to get a hold of the victim. Scott, that number that your attorney gave you isn't a good valid number right now either. So basically what the agreement is between the city and Scott, he has some expectations about being able to engage in parenting time that are a little bit, I don't want to call them hypothetical, but they're something that's going to have to be worked towards as he gets himself with his feet underneath of him, transitioning out of an inpatient facility. If it becomes, right now there's a third-party contact provision that the parties have jointly proposed, even though the victim isn't a part of this discussion, because Scott indicates that he has these abilities to have contact with children that are a part of the family law case. But if at a later date that it makes more sense to have.
That's not, the children are not, those matters I think are being dismissed.
Correct.
So this court doesn't have jurisdiction to discuss contact with the children or things like
No,
that.
no, and he understands that. The no contact order allows for contact via third party to coordinate visitation so long as there's a parenting plan order or something along those lines.
I'm assuming that's what was proposed by
Correct.
the city.
Yeah.
And it is agreed that the domestic violence treatment condition is stricken, it looks like, on the PTA.
It's actually free to argue, Judge. So I think the city is asking for that to be imposed. My client doesn't have a financial means of doing it. If he's ordered to do it, he'll do his best to try, but it's not covered by insurance. And I just think it's a recipe for failure. I don't believe that he'll be able to do it. If you look back at the PC statement, this was a situation that had some undertones of. Go ahead.
So he's getting credit times. So I'm just trying to figure out, there's any that either other than the no contact order.
Mhm.
There's any conditions moving forward other than probation, certainly good behavior.
Stay out of trouble and don't have contact, absent to no contact.
So-
And then the
so-
DV provision, Your Honor, imposed.
So, Your Honor, the city is asking for the domestic violence treatment, evaluation and treatment. I understand that Mr. Yeaman has some limited means due to his lengthy mental health hold. However, he is, I believe, employable. This is a 5-year probation period. I think at some point here, maybe 6 months down the road, he should be able to pay to start making a wage again, hopefully, and start doing the domestic violence treatment. I think it's appropriate in this case. So the city's asking for that. I did agree with Mr. Campbell that I would not oppose him making a pitch to the court, and letting the court decide. However, the city would be requesting that.
Okay, but so my understanding, there was a protection order. I don't, so you also said that there was cases in Oregon.
Correct. There are no contact orders in Oregon, though. I want to be
I
clear about that.
understand. My question though, does he have a domestic violence treatment condition in Oregon?
Scott, do you have a domestic violence treatment in Oregon?
No.
And I guess the issue that I'm I don't see, I mean, certainly a person can get a protection order violation. The court has clearly, a superior court reviewed it, found that there was a necessity for protection order. I don't see an underlying domestic violence charge, though. Let me look at his.
There are
I could be wrong about that.
Well, and I can say very clearly that there are allegations of domestic violence that are uncharged incidents in the police reports. I'll be fair to Your Honor and the state and city in that regard. He was on an ITA hold when.
No, I know. He's been appearing in front of me for the last year from facilities the entire time. So I understand what's going on. I'm just trying to figure out. I don't know. I'm trying to figure out exactly what the intention is. So very clearly. All right, so I'll just proceed to sentencing. We're doing pleas on counts 1 through 3. My understanding is that counts 4, 5, and 6 are being dismissed pursuant to plea today.
Correct.
Count 1, 364 days in jail with 354 days suspended, leaving 10 days to serve. It'll be a $5,000 fine with all 5,000 suspended. I am finding that Mr. Yeaman is indigent. Count 2, 364 days in jail with 354 days suspended. Again, 10 days to serve. $5,000 fine, all 5,000 suspended. Count 3, 364 days in jail with 354 days suspended, 10 days to serve. Again, 5,000 with all 5,000 suspended. Total of 30 days. Credit for 30 days. Probation for 60 months. Total financial obligation, because I am going to charge the domestic violence DV assessment, and I'm going to charge it 3 times. I think that's what the statute requires. So that'd be a total cost of $45. Conditions, no law violations, bench probation for 60 months. My assumption is that there is some manner of domestic violence, something or other. If it's not in Oregon, it's in a family law plan, or maybe it exists somewhere. If it doesn't exist somewhere, my perception would be it doesn't exist somewhere for a reason. I could be totally wrong on that, or I could be totally right on that. I don't know. I'm not going to impose it at this time. In particular, if he's been in a facility for the last year, I just think, again, this is not a circumstance where we're going to be able to attain that. That said, Mr. Yeaman, if you continue to have issues with the courts, the court has jurisdiction over you for the next 5 years, sir, to certainly take appropriate action. I am not going to set a review date at this time. I don't think there's any active conditions for the court to be reviewing.
And just in fairness to Mr. Busby, because this is a transitional phase for him, I think that there was a provision for continued compliance with mental health treatment in the PTA. I'm not asking Your Honor to monitor that. I mean, it's been a year that he's been in these inpatient facilities. If Your Honor wants to, I just wanted to note that for the purposes of being upfront and candid.
Yeah, I'm not going to add that condition either.
Thank you, Your Honor.
All right, thank you.
Scott, you don't have future court dates out here. Stay out of trouble and continue to do what you need to be doing.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.